Oh, good morning, everybody. I hope you can hear me. Greetings from Paris, where we're expecting the temperature to hit 42 degrees again today, as it did yesterday. I was in St. Petersburg earlier in the month for the Economic Forum and would have been very happy to be with you for the Legal Forum as well. But there we are. I'm with you virtually instead. The issue of the panel, the subject of the panel is, of course, double standards in human rights. And as I'm sure you all know, everybody in this room knows, this is not a new problem. We all remember how NATO attacked the Federal Republic of Yugoslavia in 1999 on the basis that Serbia was committing human rights violations. And we know 20 years later that it was the other way around. The then leader of the Kosovo Liberation Army, Hashim Thaçi, is himself now on trial for very serious war crimes. We also know, and you all know in this room, that 10 years or so after the Kosovo war, NATO then attacked Libya, also on the basis of human rights. And the goal of that operation, allegedly, was to protect civilians. The importance of the Libya intervention in 2011 is that it was, unfortunately, validated by the United Nations Security Council. So we can say that in terms of international law, unfortunately, human rights have now entered the domain of international law, have been validated by international law, in this case by a Security Council resolution. And I say unfortunately because there used to be a Roman principle, a principle of Roman law, ex injuria lex non oritur. So law cannot come from a violation of law. In this case, unfortunately, law has come from a violation of law. The Kosovo precedent served to justify the Libyan attack, the attack on Libya. In domestic foreign human rights legislation, we have the same problem. The first speaker, Grigory Lukiantsov, referred to the European Court of Human Rights. Many of you, I'm sure, are familiar with the ruling called Klima Seniorinnen in 2024, a ruling which awarded some associations which were campaigning for climate policy in Switzerland. The ruling found in favor of these associations representing old ladies. And yet this ruling, this 2024 ruling on Klima Seniorinnen, is an absolutely textbook case of how human rights legislation in the European case has been turned on its head. The original goal of the European Convention was to protect people, protect individuals from excessive state power. And yet in this ruling, it's exactly the opposite. The court is not protecting individuals from the state. It is, on the contrary, making demands on the state to act. And this ruling, from a legal perspective, is addedly fascinating and regrettable because it found in favor of the claimants, even though it found that they were not themselves victims. In other words, the court has simply turned itself, the European Court of Human Rights has simply turned itself into a policy review body. It's absolutely nothing to do with human rights because there was no violation of human rights. So these problems are old. They date from at least whatever it is, 25, 26 years ago, 27 years ago, 1999, and they are set to continue. Again, I'm sure you all know that the European Commission, the Council of Europe, and Ukraine are setting up a special tribunal for the crime of aggression against Ukraine. Well, the very title of this proposed body violates all the principles which the great 19th century British constitutionalist A.V. Dicey laid out as definitive of the rule of law. Dicey said, by the rule of law, we mean that nobody can be punished without a ruling by the ordinary courts according to the ordinary legislation of the land. So if you create a special tribunal, by definition, you are not obviously in the ordinary courts of the land. And moreover, in the title of this body, this proposed body, the crime is supposed to be aggression against Ukraine. Well, that's a blatant example of double standards because according to that logic, there should, of course, be a crime of aggression against Iran. So my view is that these violations, these double standards, are old. They are unfortunately embedded in international law, as I mentioned with respect to Libya, and they will continue. And the reason why they will continue is that they belong to the very problem of human rights. There is a systemic problem with human rights. This is not a deviation. The problems that we observe is not a deviation from human rights. It's absolutely systemic. What I mean by that is that when you read for example, the European Convention, or for that matter, the international covenants on civil and political rights, whose anniversary we are celebrating, you can take almost any article. You can take Article 8, the right to private life, Article 2, the right to life, Article 10, free speech, the list goes on and on. And the way these articles are structured is that you have a principle, so there's a right to life, or there's a right to free expression, or whatever. And then in the second paragraph, you have a whole list of pretexts under which that right might allegedly be limited. And that applies, by the way, even to the right to life. There's a whole second paragraph about how the right to life can be limited. Now, that means that the original right, which is allegedly stated at the beginning of the article, does not exist in legal terms. Instead, it is handed over by the article itself, usually in the second paragraph, to the legal system, to the judicial system, to stipulate how this general principle applies in particular cases. But if you say that it's not the principle, but instead the legal system which decides how the right applies, then you are undermining, as can only be the case, the whole notion of human rights. The whole notion of human rights is legal nonsense. It's legal nonsense because the articles themselves hand over to the judicial system and to the law the way that these rights should be interpreted. And that is inevitable, and in some ways that's a good thing. But it shows what Grigory Lukiantsev said just now, which is that everything depends on interpretation. And that's why I am convinced, and I've said this before at the Legal Forum, that the notion of human rights needs to be abandoned as a legal concept. It is not a legal concept. At best, it's a moral and political concept, but in no way can human rights be understood to be a legal concept. That's why I say they should be abandoned. Instead, what we need is justice. That is the concept that should guide us, justice. Justice cannot come about from international organizations, because international organizations are by definition detached from the countries over which they wield power, over which they adjudicate. Instead, by justice, we understand the weighing up of the pro and the contra, of the for and against. We weigh up the claims of the different claimants in a case. That's what a judge does. That's why justice is symbolized by scales, because we take genuine things in genuine societies and weigh them up one against another. That's how we try to avoid double standards, by comparing things. And that can only happen in a national context, in a national legal context. And so that's why I say that the concept of human rights cannot be reformed. It cannot be refined. It is structurally deficient in a legal sense, and therefore, in my opinion, should be abandoned. Thank you.